All right. Okay, so just one point which I did not cover on this particular case in the last class, which is if you read the first line, appeal by special leave. All right, so this is something. So this type of information, I mean, the stuff that we are discussing now on this case is not related to the central learning. I mean, the central legal point in this case, but this is in the nature of other learning that we can derive from this case, other aspects of the case which give us an opportunity to take a detour into some other area. Okay, so here what we do is, I'll just put this here. Alright, is the font big enough? Yash at the back? Okay. So, where were we? We have to go here. Alright, okay. So here you notice the second category of learning, which is other incidental things that we can pick up from the case. You notice here it says appeal by special leave. Alright. So whenever you see this this will always appear only in a Supreme Court judgment. You can see this once again when you see this kind of citation. AIR 1966 SC. Okay, so this AIR is All India Reporter. It's a law journal, and then or it's a law reporter. Okay, and then this SC is the clue that this is referring to the Supreme Court part of the AIR, of the All India Reporter. Okay, so here this tells you that this is a Supreme Court case. Another clue that this is a Supreme Court case is this expression, appeal by special leave. All right, so this appeal by special leave. All right, this takes us into so we're going to use this expression to learn a little bit about the different ways in which you can appeal from lower court judgments, and we'll just focus on the judgments of the High Court. Okay, so what you have here, if you see that there is this appeal by special leave is happening under Article 136, which is here 136. I put all these links in your notes. All this stuff which I'm putting in here in the draft notes will then be pasted into your version of the S underscore contract law notes. Okay, so this will all be there for you. Now what we are just showing you is that there is this Article 136, okay, which tells you that okay, so there are the other provisions that we're going to look at is Article 136, and then we're also going to look at 133, 132, 134, etc. Okay, so if you see here what it says in Article 136, we learn about something else, which is this expression. I can't copy it from here, but this expression. So what you see here are the text of Article 136, and we're also going to learn something else here. This expression that we have, notwithstanding. Okay, so what 136 says we'll come to later. So this notwithstanding again implies, this is actually called there's a legal term for this. This is called a non-obstante clause. Okay, so whenever you see this kind of structure in a legal provision, this is referred to as a non-obstante clause. This notwithstanding anything contained in this chapter. Okay, what happened here? I clicked on something and it just disappeared. Yeah, okay, I must have clicked. Oh, I clicked on this notwithstanding. Okay, accidentally. So when you see this kind of wording in any legal provision, whether it's a constitution or a statute, this notwithstanding anything in this chapter, notwithstanding anything in this act, this kind of expression, okay, is referred to as a non-obstante clause. And what this means essentially is that, see, in this chapter, what you have in this particular chapter, why are they saying anything in this chapter? Because the other provisions that we are going to discuss, 132, 133, 134, okay, all these things are all in the same chapter. All these provisions are in the same chapter, and this set of provisions, 132 to 134, deals with the high courts, where you can have appeals from decisions of high courts, and they're all in the same chapter. So 136, when it starts with this kind of a notwithstanding anything in this chapter kind of structure, okay, with a it starts with a non-obstante clause, which means this overrides all the other provisions. Okay, so notwithstanding anything in this chapter, I mean, basically it doesn't matter what anything else in this chapter says. That's the meaning of notwithstanding. Okay, that means forget about what is written anywhere else. What I'm saying, what I'm about to say now is the final word. Okay, this is the meaning of this kind of structure. All right, so here you can see that this appeal by special leave, that means this particular appeal was made under Article 136 to the Supreme Court of India. This was made as these are called SLPs. These are called special leave petitions or SLPs. Okay, so Article 136, these are called SLPs. I'm not writing the full form, you should remember it now. SLP obviously by special leave, okay, and the P is for a petition. So special leave petitions or SLPs. These are made under Article 136. So you get the right to petition the Supreme Court by special leave under Article 136. So everything that you can do or you cannot do, everything is governed by some particular provision, either of the Constitution or of a particular statute. Okay, so that's what we have to learn. This is again going to be a very formalistic approach. Okay, so you can't do anything just out of thin air. Everything that you do has to be based on some kind of sanction from the Constitution or a particular act. Okay, so 136 we have already seen. We have seen the structure of this this article, and we've learned about what is called a non-obstante clause. And then we see the others, 132, 133 and 134. A very simple structure. You see it here. You start with 132. So it's talking about appeals from decisions of high courts. Okay, so 132 broadly is talking about any kind of I mean, here if you see there's a constant reference in 132, 133, 134 to if the High Court certifies under Article 134A. If you remember, Tanya was mentioning earlier in the course where she was saying that you can't ordinarily appeal from decisions of high courts. Okay, so it is actually correct in the sense that appealing a high court decision is not that simple. Okay, there's a bunch of hoops to jump through, and of course you have 136 as a catch-all kind of escape clause, but then the 136 petition need not always be allowed by the Supreme Court, and many of them are rejected. Okay, so it is true that it is not a clean shot to necessarily be able to apply the appeal a decision of the High Court. Okay, so the first provision is that the High Court, if the High Court feels under 132, the High Court will refer a case, will certify a case under 134A, read with 132, Article 132, if it feels that this particular case involves a question of law as to the interpretation of this Constitution. If it's a constitutional question that is involved, then the High Court will certify under 134A by reference to 132. Okay, so 132 is talking about questions of constitutional related to the interpretation of the Constitution. Okay, so if the High Court feels that this particular case that they have decided involves a constitutional question, okay, then they will certify it. Okay, in all cases the High Court will certify it. Okay, 32, 33, 34. But if they will certify under 132, read 134A read with 132, okay, if they feel it's a constitutional question. Once you see 133 and 134, you will understand the difference. Okay, so 132 is under if there is a constitutional question involved. Okay, like one of your sale of goods cases that you're going to do, that involves a constitutional question. Now 133 is slightly different. 133, if you see, it's talking about in civil matters, the High Court will again certify a case as being fit for appeal. Okay, under 134A, it will certify a case as being fit for appeal. Under 133, read with 133. Okay, if this is not a constitutional question, if the question is not a constitutional question, but it's a question of substantial question of law of general importance. Okay, like if it's something in the Contract Act, what is public policy of India? Okay, so we know that certain acts of consideration is void if it is opposed to public policy, unlawful. Okay, so what is the interpretation? How should we interpret this expression public policy in the Contract Act? This is not a constitutional question. It is a question of law but it is a question of law because it relates to a interpretation of a statute. Okay, so then in this case, in such a question, in such a case, the High Court will again give a certificate of appeal under 134A, but this time it will be read with 133. Okay, so when you see 134A, you will see again it makes reference to 132, 133 and 134. So 132 is for constitutional questions, 133 is for general questions of law in civil cases, okay? And then 134 is going to be then what? Is for criminal cases, okay? Because if you leave out 132, which deals with constitutional questions, so then 132 is dealing with civil matters of general importance, general questions of law. And then obviously then 133, sorry, if I said 133 is dealing with civil matters, and then 134 is dealing with criminal matters, okay? And there is a special situation in the criminal matter, not all criminal matters, that if they have actually sentenced somebody to death, that is basically what it is, okay? So if the High Court gives a death penalty, to somebody else, to some accused, okay? And in those cases, okay, the High Court will actually, they can also certify otherwise as something fit for appeal. So essentially criminal cases, all right, where the High Court will have to certify. So this 134, are you following the broad structure? So the 132 is dealing with constitutional questions, 132 is dealing with general questions of law and civil matters. So any kind of interpretation question with respect to some statute in a civil matter. And then 134 is dealing with, I don't know what I said, 33, or actually it should be 33, okay? Yeah, it should be 33. And then 34 is dealing with criminal matters, okay? Any other criminal matter, you see A and B are dealing with death penalty. A and B are dealing with death penalty when a person has been sentenced to death by the High Court, okay? So, and the C is actually that the case is a fit one for appeal, as any kind of criminal case which the High Court feels is fit for appeal. The High Court can give a certificate of appeal to the to appeal, go and appeal to the Supreme Court, okay? Right, now if you see, now having done all these 32, 33, 34, now you see 134A, okay? See 134 saying every High Court passing or making a judgment, etc., referred to in clause, you see now it's referring to 132, 133 and 134. Can you see that? 134A is referring to 132, 133 and 134. So which means essentially it's a question of what we should have studied earlier, whether we should have seen 134 earlier or we should have seen 32, 33, 34 earlier, okay? Whether we should have seen 134A earlier. So I've just chosen to show you 134A later, okay? So essentially what it says, so what is 134A saying? That if the High Court feels that there is any question of constitutional importance, it can use 134A read with 132 to refer it to the Supreme Court on its own, okay? And if the High Court feels that there is any question of general importance of some kind of a general question of a question of law of general importance, like interpretation of public policy in the Contract Act, then again it will use 134A to refer it to the Supreme Court, give a certificate of appeal to the Supreme Court, but this time it will do so under 133 because it's a general question of law in a civil matter. Is this clear? Or if there's a Transfer of Property Act, what is the meaning of notice? Under Transfer of Property Act, there is an important definition of notice, okay? Does somebody have notice of something, of some fact? Then there may be a dispute about what is the meaning of notice. Okay, so if there is a dispute of how to interpret the word notice in the Transfer of Property Act, that would become, again, that would come under which article? 32 or 33 or?
33.
It should come under 33 because Transfer of Property Act is a civil case. Okay, so Transfer of Property Act would be a civil case. So in a civil case, litigation in a civil case, if there is a question of law, and this is a question of law of general importance, if it's a provision in the Act where the interpretation is not clear, okay, then the High Court will refer it again under 133, okay, under 134A read with 133 by making a reference to 133, and as you can see here, it is referring to 133 also here, and then 134 also, okay. It can also refer for criminal cases, okay. It can also refer for criminal cases, and then obviously what has to be done is when you lose a case in the High Court, you have to be the High Court can do it on its own motion, okay. That is, you know, there's this own motion. We use this other expression. Let's put that also here so that you know it when you hear it. Okay, own motion. Let's talk about 134A. I've not copied 134A for you. Okay, let's have 134A here, and then own motion is also referred to as, you may have seen this expression, is suo motu, okay, basically on its own. All right, So if the High Court, this is a suo motu means some kind of event where the court is taking cognizance on its own motion, on its own, without anybody moving the court, without anybody petitioning the court or applying to the court for anything. The court is doing it on its own motion. Suo motu means on its own motion. Okay, you might hear this expression somewhere. Okay, on its own motion. Okay, so we are actually using this. So there may be a little bit complicated here. It may seem a little complicated to you, but it's important to use this expression since we've seen this lead-in saying by appeal by special leave. So we can use this sort of opportunity to take that little clause and then learn about what are appeals by special leave and the whole structure of appeals from the High Court. Okay, so you have these three. So you have 132 for constitutional questions, 133 for general civil law questions, 134 for criminal law questions. Okay, and all those are connected to 134A, which essentially, what does 134A do? It actually allows the High Court. Again, I've clicked. I'll get a 404 error. Let me just go back. This actually, I find this because it's very difficult to get a good constitution website where I find, unfortunately, this actually is a US site. Constitution.org is a US site, but I find their arrangement of the Indian Constitution to be the best because it gives me a hyperlink based structure and a chapter by chapter based structure. So I use this website for because the other ones we have are not, they don't have all these facilities. Okay, so 134 is a general provision that gives the power to the High Court to refer to 132, 133 or 134 depending on the category of the case, and make a reference to the Supreme Court. Is this clear? Okay. All right. So yeah, the High Court can do so on its own. Otherwise, if the High Court is not doing so on its own, then your advocate, if you've lost the case in the High Court, then your advocate should, if an oral application is made immediately after the passing or making of some judgment. Okay, which means you can't waste time. So as soon as the High Court rules against you, your advocate should make an oral application to the court that you should, determine. Okay, you should make an application under 134A clause B. Okay, under 134A clause B, you should make an application so that the High Court can determine, okay, whether any kind of certificate of appeal can be granted under 132, 133 or 134. Okay, the point is basically because 134A, you can get a certificate of appeal in two ways. Either the High Court will do it on its own. Okay, if it doesn't do so on its own, you have to ask the court immediately to please determine whether this is a case fit for appeal under 132, 133 or 134, as the case may be. Is this clear? Okay, now you see why you need the backstop of 136. Okay, because see what might happen here. The High Court, A may not happen. You lose the case in the High Court, A may not happen, the High Court may not be bothered, the High Court may not think that this is a case that requires appeal to the Supreme Court. So the High Court doesn't do anything on its own. Alright, but your advocate requests under 134A clause B. What is the High Court, what is your advocate entitled to request? He cannot demand that a certificate of appeal be given. Notice what this 134A clause small b says. What does it say? Shall, the High Court shall, okay, if an oral application, what should the High Court do? Shall means you have to do it. Okay, in general we say may means you may or may not do it, but shall is compulsory. Okay, in general, there are some exceptions. But High Court shall, what is the High Court compelled to do? Shall determine, okay, the question whether a certificate of the nature referred to 132, 133, 134 may be given. So the High Court is not compelled to give the certificate. The High Court only is compelled if the advocate makes a request as soon as he loses the case. The High Court is only compelled to make a determination, that means to consider the question of whether this is fit for appeal to the Supreme Court. Okay, are you following what the High Court is compelled to do? Under 134 capital A clause B. Under 134 capital A clause B, the High Court shall, if an oral application is made, shall do what? Shall determine whether, I'm just reading out the keywords, shall determine whether a certificate may be given. Okay, Because the High Court has not, see, A has not happened, clause small a has not happened, okay, because the High Court didn't bother on its own. Now your advocate has made a request under clause small b of 134A. But what does this compel the High Court to do? The High Court is not compelled to give a certificate. The High Court is only compelled to address the question of whether a certificate should be given. This is clear. So I am not compelled, let's say, what happened here? You're going to take care of it, or Gulati, or who took care of it last time? Okay. What happened here? Oh, okay, I know why this is happening. Actually, I didn't even see my voice is coming through the mic, but I didn't even put this mic near my mouth, but it's still coming. Let's see. Alright, so then might make it worse. Okay, guys, is this clear? Are you following the point?
Yes, sir.
Okay, Yash is losing interest. What? Are you there? Okay, we still have 15 minutes to go. I don't know how this is how we are gonna cover the two cases, but I spent a lot of time on this. We might just stop here, but anyway, let's see. Okay, so yeah.
So the structure is not clear. What is a section? What is an article? Can you explain that?
No, in the there is no section. In the Constitution, we only talk about articles. Okay, so you can say what we would say. We would say that this is clause B, and if you want to make a distinction, because this article is 134A, so if you really want to make a distinction and not confuse between A and B, you might want to say Article 134 capital A and clause small b within Article 134 capital A. Although normally people don't talk like this, but I think it's better to make it clear so that there is no confusion about the A and the B.
So like in Contract Act, you said the section 2 of Contract Act
Yeah.
the various terms
Yes.
in the Contract Act.
Interpretation clause,
So
yeah.
where would the term article come in the Contract Act?
Article is the expression that no, there is no article in the Contract Act. When you're looking at acts, okay, so you have to understand that Constitution is a high level document. So the Constitution is not on the same level as all these acts. Whereas all these acts like Income Tax Act, Transfer of Property Act, Registration Act, these are all on the same level. These are what we call statutes. The Constitution is like a mother document, okay? So it's a high level document. It doesn't really sit on the same level as these particular acts. This is clear. So the provisions of the Constitution in India, the Indian Constitution, we call the particular provisions, we call them articles. They're all named as articles. They're all labeled as articles. Article 1, Article 2. Okay? So Article 14, where the equality provisions and the equality clause in the Indian Constitution, that is Article 14. Okay? So all the parts of the Constitution, if you go back and just play with this, if you play with this here, okay, look at this, Constitution Society. Can you see this? Okay, here you go back to the home part here. Go back to the home part here. Okay, if you go back here, you'll see they're all arranged as articles. Okay, all right. Okay, okay, all right. Right. Okay. So where are we? Clause B. Are you guys confused? One sec. Because don't laugh. We have to make sure that people don't get confused, and we have to stay focused. Yash is already drifting away in the back. At the back. Okay. All right. So let's focus. Is this clear what Article 134 capital A clause small b compels the High Court to do? It does not compel the High Court to give you a certificate fit for appeal. Certificate that this particular case is fit for appeal to the Supreme Court. This is clear? It only compels the High Court to decide that question. The High Court may ponder that question and still decide against you. This is clear? It only requires the High Court, because A has not happened, clause small a has not happened, High Court has not applied its mind on its own. That's why clause small b is given to you to request the High Court to at least address that question. And then the High Court might address that question and still decide that it is not fit for appeal under Article 132 or 33 or 34. Are you following? Have you followed the structure? Okay. That's why you need 136. The fallback of 136, which means that under 134A you can still lose, even under clause small b. because you may request the High Court may address that issue, and it may form the opinion that your case is not one that qualifies for appeal to the Supreme Court under 132, 133 or 134. This is clear? So now you're stuck. You would like to appeal to the Supreme Court, but you seem to have reached the end of the road. But there is hope in the form of, where is the hope? 1 minute. Here is hope, okay? Alright. So now what does 136 say? Remember 132, 133, 134 are all part of the same chapter. They're all part of the same chapter. Okay, so in the Constitution you have chapters, and then within that you have the individual provisions of the articles. Okay, so what does it say? Notwithstanding anything in this chapter, which means never mind what 132, 133, 134, 134A or anything else in this chapter says. I am the final word. And what is the final word? The Supreme Court may, in its discretion, again Supreme Court is not compelled to hear your appeal, but the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, determination, sentence, order, etc., etc. Is this clear? So obviously, there's an exception here. Armed forces tribunals are not included. Okay, so that is understood. All right. Okay. Now, so are you following the structure now? So the main clause for High Court to certify is under 134A. 134A is to be read with 132 if it's a constitutional question, with 133 if it's a general civil law question, 134 if it's a criminal law matter. Okay, and then under 134, if your advocate petitions and the High Court still refuses to grant you leave, you do have the fallback of 136. You can come to the Supreme Court and file an appeal by special leave through an SLP. Okay, the special leave petition, and then the Supreme Court will consider your petition and decide whether it's going to grant you the leave to appeal. This is clear? You followed the structure now? Okay. So this is a long answer to Tanya's question of the High Court observation that the High Court decisions are difficult to appeal, that you can't appeal from the High Court. This is clear? Okay. So now what has happened in the Madala case? What was happening? Did they succeed under Article 136?
Yes, sir.
Some people are confused at the back.
Yes,
Sejal?
Yes, sir.
What happened? You're almost asleep, I think. She's just holding her head up like this. Otherwise, the head would have just fallen. Okay. Alright. What do you think? Did the Madala, did the Union of India succeed when they filed their SLP before the Supreme Court in this particular case?
Yes, sir.
Yes. Why? What makes you say that? No, but there's something in front of you, right? What? Very simple answer. Shweta? Do you have anything to add? Can you help Sejal? No? Sejal is nodding on your behalf saying that she can't help. Okay. So the answer is very simple, because what does it say? Is the court hearing this appeal or not? They're giving a judgment on this particular appeal, right? So they are getting this appeal by special leave. The very fact that the appeal by special leave is being heard and decided by the Supreme Court means that they have accepted this SLP. Because the petition initially is just to hear this appeal. And when the petition is granted, so when you apply under the SLP, under the Article 136, okay, what the Supreme Court will do, what is the Supreme Court deciding in that petition? It is not deciding the merits of your case as to how many units, how many mons of jaggery the Indian Railways is allowed to cancel. It's not hearing that. That is not what the SLP is about. The SLP is about, you make a reference to the underlying case, okay, you briefly describe the underlying case, and when the Supreme Court grants your SLP, when you file the special leave petition before the Supreme Court under Article 136, two things can happen. Either the court may dismiss that, dismiss that petition, okay, or it may accept the petition. Okay, they may grant the prayer in that petition. Okay, two things can happen. If they dismiss it, that means you're gone. Now you have nothing else. You no other recourse. Okay. Now you can go for a curative petition, but that's generally it's very rare. Okay. So generally you're gone. But if they grant your petition, okay, if they have allowed your special leave petition, what that means is, okay, now we are going to set a separate date to hear your case about all these jaggery amounts that were ordered and how many were cancelled. So that, are you following the difference? So the first special leave petition is just to agree whether to hear the case or not. And then once it is agreed that they'll hear the case, that's when you get the hearing and then you get this judgment. Just clear? So when they're giving the judgment, they will mention that this is an appeal by special leave. And that means when you see a judgment like this means that the Article 136 petition was successful. Is this clear? Okay. Alright, so this is your, so we had a little bit of a discussion on constitutional questions. I hope people are not confused. Are you confused? You're confused. Okay. Who's this? Sahil. Okay, good. Now if you're confused, you go home and revise. Go home and revise. Okay? Okay. Alright, 1 minute. Okay, 4 minutes. We have only 4 minutes left. 1 sec. Let's see what we can discuss.
You can wish each other Merry
Alright, okay. So in this case what we'll do is we'll probably just let it, we'll stop here. 1 minute, let's see. So, 1 minute. So, we are going to discuss this later on. We'll discuss these consideration cases later on. We have 2 cases in consideration to discuss. Okay, we'll discuss this and this as well. Okay, so now let's get your responsibilities clear. 1 sec, guys. 1 sec. So, you are now going to do which 2 cases? 1 minute. When is our next class? Okay, so you're going to do Guildford Motors and Ashbury Railway Carriage. Okay, be ready with those 2 cases. Alright? Okay, so we can give you a little bit of grace here. Oh, almost 5 minutes of grace. That's a lot of grace.